Good afternoon, everybody, and welcome to today's webinar. I'm Gary Allen. I will be your host today, and thanks for coming as we talk about financial disasters in law firms and how to avoid them. So, as many of you may know, this webinar is designed for ALA, Association of Legal Administrators Credit, for CLM or Certified Legal Managers. Just out of curiosity, could you raise your hand in the chat if you're an ALA member? Do you have any ALA members who have joined us today? Oh, there's a couple. Cool. Well, welcome. And for those of you who aren't ALA members, we are big fans of this organization. If you want any information about joining ALA, or we will put your name in the chat and we will put you together with someone from your local chapter who can help you decide if that's a good fit for you. So thanks for coming today, and let's move into the webinar. I'd like to just start with a brief introduction of myself. If you don't know me, I'm a 35-year practicing attorney in a mid-sized firm. So like a lot of the firms in the ALA community, I had some bad experiences when I started practicing law. Particularly, I was involved or was present for two firms that blew up while I was there. And that was very painful from a lot of perspectives. One really memorable part of that is that one Saturday afternoon, I was left with no job and a 6-month-old baby to feed after one of my firms had collapsed. So, that was very memorable. And what it did for me, after I landed on my feet and worked in a really exceptional firm for over 30 years, is it gave me a real passion to help law firms and make law firms into better businesses. And what you'll be hearing, some of what you'll be hearing from me today is just what I learned in that period. And I think there are ways for firms to become exceptionally well-run financially, which makes everybody a lot happier. And I'm hoping that you'll want that and help start adopting that for your own firm. Finally, along the way, I founded Lien Law, which is a legal billing software company. Now, I'm really excited today to have Matthew Sullivan with us. If those of you who are ALA members may be familiar with Matthew, he's a frequent speaker. He is Executive Director of Operations at a law firm, Sullivan Law, also a business consultant. Matthew, do you want to say a few words?
Yeah, thank you. I'd love to. Yeah, to our ALA members here, I too am a member of ALA. I am chair of the Professional Development Advisory Committee. I'm also on the annual conference planning committee. So heavily involved in ALA, and really appreciate all that they do for us administrators out there. But yes, I do have a day job at a law firm, Sullivan Law and Associates. It's a family law firm. I am related to the founding partner there, as you might have guessed with the name. And I also do have a consulting business called Unravel Legal, which focuses on finance and operations and a touch of HR with small, solo firms that need help in trying to get their business practices right and on the right track and continued success on that level. So yeah, that's about it from me.
Thank you, Matthew. Yeah, Matthew and I have had a number of conversations over the previous months, and I can hear the passion in his voice when he talks about helping law firms become better businesses, and he's got some really good stories and of course good advice for firms that want to improve. So thank you, Matthew. Really appreciate your being on the program today.
Yeah, thank you for having me.
So here's what we're going to try to accomplish today. When we're done, I hope you'll understand what I call the $8 million difference. So these are the essential things you need to do in order to achieve the best-in-class financial performance that I was fortunate to experience during my legal career. And that is about efficient processes, productive people, and strong product market fit. So there are 3 Ps in there: process, people, and product. And we'll talk just a little bit more about that. And then, of course, what Matthew's going to focus on is how to avoid some of the really bad things that can happen in your firm financially. We've got a few scenarios that we're going to talk through. So let me just introduce this topic of the $8 million difference and what I call best-in-class financial performance. As I mentioned, there are 3 aspects to this. The first one is, and as I've more thought about this, the more I think this is the best starting place for firms that want to improve their financial performance, and that's efficient processes. And processes are about, or things that you do over and over again. And the way to start improving them is to write them down and understand them. So you want to map out your workflows. Then we're really big on the idea that you should build on industry standards in your firm. Everybody out, almost all of you are using MS 365 or certainly Microsoft products. There is a lot of power in that system that with the right help, you can bring that out and it'll really help your firm get a lot more out of something you're already using and paying for. And it's highly customizable in the way that all-in-one practice management software isn't always. The other part of it is QuickBooks Online, which is the de rigueur finance tool for mid-size or for small to mid-sized businesses. And you take those things, you build them up as much as you can, and then you add legal customization. And that's part of why lien law exists, although it's not the only choice in that respect. But we customize QuickBooks Online for small to mid-sized firms. And then, of course, you have to communicate those processes so that they're actually adopted within your firm. With efficient processes in place, you're in a good position to think about making sure you have productive people in your firm. And that's a matter of creating the right culture so that people are self-motivated and accountable, a right compensation system. If you've watched me talk at all, I'm a big fan of objective compensation systems for creating trust and predictability and getting the right accountability from people. And then finally, succession, because a law firm that's going to end when the founder retires is not all that attractive a place to work. Then the final part is strong product market fit. And this is probably underappreciated in law firms of really thinking about how your services look from the point of view of the client and making the best fit there. And this is especially true these days when you have the opportunity maybe to offer some, technological aspects to your offering, like a portal or online resources, that sort of thing. So I'm a real fan of using design thinking. We won't get into what that is, but that's a really great way to figure out what your clients are really looking for and design the best products for them, the best pricing, and then marketing appropriately to your market. If you can do all of those things, you can, if you're an average firm today, you can potentially triple your profitability over the course of a 40-year legal career. That adds up to $8 million for each lawyer who is fortunate enough to work in a system like that. Okay, enough on that. I just want to briefly say that we have programs on all of those aspects that I just talked about. We've done several over the last few months, which you can view on our free online community called that's available at lienlaw.com/learn. And going forward, we have a bunch of new programs. We've already talked about your financial report card. How are you doing? Compensation, best-in-class technology, how to use MS 365, some of the people issues that you have. Today, we're talking about financial disasters, and next week, we'll be talking about how to keep people from poaching your lawyers with Sharon Abrahams, who's a great speaker. More on law firm efficiency next month with Lisa Woligorsky, also a big ALA speaker. There will be a security session in December. And I won't get into the rest of these, but we've got 2 of these every month if you want to keep learning about how to achieve best-in-class financial performance. Sorry for all the small print here. You'll be able to read all of this on the replay when the webinar is over. Then finally, we'll, at the end of this, we'll show you how to download your own financial report card, and it helps you to see where you should focus your strategy on improving your financial performance. All right, so now let's get on with the main event, avoiding financial disaster. And we've set up 3 scenarios to talk about different bad things that can happen in your law firm. And Matthew's going to help us understand how you avoid those things. So the first one, disaster number 1, it's late at night. I'm reviewing my receivables. I've actually done this on a couple of occasions over my career. And I noticed that a firm litigation client is now more than 90 days overdue on their bills, and they owe the firm over $100,000. It's a smallish firm. Let's say that's a lot of money for that firm. And something you experience if you've been in these things is a lot of times they get behind. Your client gets behind on the bills at a really sensitive point in their case, when you're in a difficult position as a professional to say, sorry, you're not paying your bills, we're withdrawing and getting out of here. And the client may be, screaming prejudice at that point. All right, so Matthew, I've given you, we're in a sticky wicket here. What should I do?
Yeah, no, well, in situations like this, I mean, this happens in firms all the time. And, going back to what I think you were speaking about previously, putting processes in place can help with not even getting to this point. I know the firm that I work at and firms that I work with, we've gone through some of these scenarios which we've learned from and put processes in place to not let this happen again. So, point number 1 is I think it's really important to determine what that sensitive point is for you. Some people have like soft or hard deadlines on when it is that they can get out of a case, because obviously prejudice is important here, and in which way you're going to be getting out of that case, whether it's a sub of attorney or you have to go through the court and have a motion granted for that withdrawal and get permission. So you have to have a strategy in place, hopefully well before the $100,000 hits, and know if you can get out and when you can get out and what that latest date is that you can actually get off that case, to just at least stop the bleeding, right, Gary? I mean, we want to want to try and stop the bleeding here if we can. So I think that's number 1 is, all right, we're in a bad point. Can we get off? Can we stop the bleeding?
So let's dive into that for just a second there. So, um, you've said the wise thing, which is, you should have thought about this beforehand and figured, protected yourself from the outset. Let's get into that in just a little more detail. So we're going back 6 months, and I'm sitting down with this client, and we're talking about the engagement. What do I say, and what do I do at that point that's going to, help create an alignment here where, I'm protected at the point that later on, if the client is unable to pay.
Well, yeah, hopefully you're having that conversation, let's call it 6 months in advance, and
Mm-hmm.
having that honest conversation with that client about what the future expenses on this case are going to be, number one. So trying to create like a plan or a budget for that particular client. And then number two, asking them if they can afford that, if you don't already know that answer. I mean, hopefully by the time you have retained the client and have been working in this capacity all the way up to this point, that you would have that answer. But should you not have that answer, just having that conversation with them, hey, these are going to be your expected costs. Can you afford this? If not, what are some arrangements that we can make to at least, try and keep this number as low as we can from the firm standpoint? Because right now we are losing a lot of opportunity costs. I'm working on cases that we could be collecting from, and this is going to
Mm-hmm.
hurt our cash flow. Right now, at this stage, um, we are going to not only be losing that revenue of the cash flow that we need in order to run our business, but now we
Mm-hmm.
are financing this case for this person. And if we can't find out a healthy situation where it can at least diminish what it is that you're going to owe us in the long run, or have some security there in family law. That's what we do with Sullivan Law and Associates. Sometimes we have to go the route of getting a family law real property lien on one of their homes and trying to
Mm.
secure, some sort of financial stability there so that we can feel better about moving on with the case. And then
Right.
should they not be able to pay, you have to have the conversation. Well, then maybe we're not the best firm for you, or we can have the conversation around trying to keep costs down on who is working on
Mm-hmm.
that case. So
Mm-hmm.
there's a lot of different options there. I mean, obviously we don't want to leave the client in the lurch and get in trouble with the court or the state bar. We want to follow all those ethical rules and bounds that the attorneys are supposed to be following, but we need to be strategic in the way that we are going to handle these cases with financial matters that are large, and they have big repercussions as to how that not only affects your relationship with the client, but also how your business is going to continue to run.
Mm-hmm. That raises a couple of questions for me. The first one is just to talk about retainers a little bit more. How do you recommend that people use retainers in these situations?
Yeah,
Um,
we've had a few interesting conversations around this topic, Carrie.
mhm.
Um, I the one that you were most in favor of, and that I know that Lien Law does very well, is the Evergreen retainer. You place an agreement with the client that they are going to be keeping your retainer at a certain amount on some period of time, so that there's always money in the trust, and that you are billing against that money, and that you are never owed money, right, Gary?
Exactly. Well, and if I can just flesh that out just a little bit from our experience, which is, setting up an evergreen retainer, especially one that kind of has automatic triggers and all the payments are electronic and, is very automated, is quite a bit of work. But the firm that that really pioneered this for us, they're a family law firm, sort of high-end divorce firm, and so I think they're having a lot of collections issues in that world, where like people with money like to really beat each other up in a divorce, unfortunately.
They really
Uh,
do.
and so they, you know, it was worth it to them to, try to get this fully automated and never be, I think they bill twice a month actually to replenish the retainers. And, they put $1 million in their pockets by moving to this system. So if collections are really a serious problem, you might want to consider something like that. But that's not for everybody, I would say. But there are,
Yeah.
if you've got that sort of high risk, fast moving, case and case where you can't get unstuck easily, uh, that's something to consider. But for your more typical client, what do what do you do with retainers?
Well, so what we've typically done at Sullivan Law and Associates, we've quoted a retainer amount. For us, we deal with people going through divorces, so that retainer ranges anywhere from 7,500 to $25,000. Just depends on the case, but really the strategy is asking more than what you need for right now and being able to give yourself enough cushion to what it is that you can see is going to happen in the more immediate future. I
Hmm.
would say you want to provide enough cushion where the client feels as though they can afford your services, but also you don't want to turn around and invoice them a month later and they're going to owe you a bunch of money at the same time.
Hmm.
So I think it's finding that appropriate retainer amount given that specific case. And number two, um, I think it's important that you are having a fair and honest conversation with them while you're going through the retainer about what the expectations are, when payment's going to be expected. Talk with them about invoicing and how often it is that you do that. And it may benefit you if you don't already have somebody who's in the position of really controlling your accounts receivable and maybe introducing them into that conversation as well. So that there's a nice handoff, there's a good relationship there, and really putting somebody in charge of those receivables, we have found has gone a long way for us with
Hmm.
our firm. And I've seen that happen with other firms that I've worked with on the consulting end, where you plug somebody into that role and you can stay on top of those receivables. And maybe it's not an evergreen retainer, but if you are communicating with them at
Yeah.
certain thresholds, so let's say you quote them a $7,500 retainer, and you're going to check in with them, and not only just on those invoicing periods, but also those periods where, right, maybe at 5,000, where they have $5,000 left in the trust, I'm going to send them this type of message at $3,500, and just have these different benchmarks on when you're going to communicate with them. And also that if you can get with those attorneys and this person is in that seat, and you can project where work is coming up and give yourself a reason for them wanting to replenish that retainer often with, hey, you have these things coming up, we're going to need you to replenish for these reasons. You're just giving yourself more reason to get paid, and then you're in that
Right. Right.
you're in that spot of leverage where they feel as though they do need to pay you for these services and not just always being owed. So working out
Got it.
ahead of that client can be very helpful.
Yeah. So you said one thing there I wanted to follow up on, which is that somebody has to own the receivables. Is that typically a lawyer or is that a staff person in the way that you do that?
So we have a staff person that does that. He's been a part of collections in other law firms and at other businesses too. They just don't have to be
Hmm.
legally related. But we have that person work hand in hand with the attorney on a weekly basis and just getting case updates and letting the attorneys know where that client sits financially, and then the attorney lets us know then where that client sits from like a legal perspective. And that's how we're able to combine forces and communicate with the client about not only where
Ah,
they sit, but what's coming up, and then
right. Hmm.
what that replenishment is actually going to be paying for.
Okay. So is your staff person there monitoring like work in progress that's coming at the same time?
Yes, absolutely.
So
And that's a main factor of when it is that we are going to be reaching out to that client.
yeah, yeah. So you actually have your attorneys trained to get their time in on a regular basis?
We we have them mostly trained. They're pretty good about it. And we also have staff that follow up with them if they're not getting their time in on time, and we just kindly nudge them and ask that they put that in because that's a big factor in being able to not only have good, honest communications with your clients, but also being
Right,
able to project well.
right. Yeah, if you have some magic there, I'm sure that, like the bottling the ability to get lawyers to put their time in on
Yeah, I mean
on a daily basis,
it
that
really
would
is a
sell
group
really
effort.
well.
Yeah, it's a group effort, and we treat everyone like the good humans that they are, and we're not rude about it. So they definitely understand why.
Love it. Love it. So we've talked a fair bit about prevention. Anything more you want to add on that front, or should we move to what do you do if you've let things slip? What's the best way out?
Yeah, so if things get to this point and you've got to get out, um, sometimes you can't get out. Sometimes you're just too close to a trial date, and the court's not going to let you out. The the client's not going to sign a sub. So you need to be a little more strategic in how it is that you may be working this case and trying
Hmm.
to keep costs down while still obviously servicing the client to the best of your ability. But um, it's just going to have to be a conversation with that client to find other means to get you paid. Otherwise, you're going to have to go down the arbitration or mediation track, and certainly don't want to have to sue them for this money. But
Right.
most of this is prevention because you can get stuck and it can be too late, and you're just going to eat a lot of cost here, and it's going to
Mhm.
put your firm in a bad position, especially if this is a big client. And you got to find other means to perhaps maybe bill on clients that have money in trust and that have a very active case to try and offset some of this loss that you're going to be taking. I mean, at the end of the day, it is really about billing on clients who can pay you and who are liquid.
Right. Hmm.
It's really important to work those types of cases, especially if you get in one of these situations where you're going to want to try and dip into that well as much as you can to try and offset what it is that you're not going to see from this collection effort.
Hmm. I want to go back to something you talked about earlier, which is the property lien to secure your fees. Yeah, I frankly have never used that in my career. Is that, tell me a little bit more about how that works. Is that California specific? Or, and how much of a lien can you take? And, how do you foreclose on it? I don't know how that works in that
Yeah.
circumstance.
So, so my understanding is that it is California's specific
Mm,
and family law
okay,
specific.
I see. Okay.
So in the family law world in California, you can put a lien on, somebody's home who has equity in the home, for, you know, up to however much equity is in there.
Mm,
And you two agree on, both parties agree on how much that's going to be. Um, you file that with with the county, with the court, and then once the property sells, you're now in line as somebody who's going to receive those funds once the home does
mm,
sell. So you do hop in line and you do get paid. However, if you get too happy and too readily reliable on this type of way to collect, um, it's great when these things hit. You have to be really strategic about when it is that you're going to do them because
mm,
this is all part of your cash flow. And if you're not seeing this money here and now, well, I need to know when this home is going to sell, or if the court is going to, mandate that both parties sell the home. Um, you're just sitting on this until something happens, and that is not money that you can then collect until that home does sell. And sometimes they're not ordered to sell the home, and you just have a lien sitting out
Yeah.
there for a
Uh,
very long time.
And can one, this is getting down in the weeds a little bit, but can one party put a lien on if it's community property? Or, I mean, you
Um,
would assume in your world that a lot of the homes would be community property.
Yes, and that is something I would leave up to one of our attorneys to give any
Ah, okay.
advice on. I'm not to be here to giving any legal advice, but just how that process works, like it's something that a lot of family law attorneys here in California do use, but at the same time, you can put your
Yeah,
firm in a
yeah.
bad situation if you rely on these too much, and if you're not strategic about
Mm,
where it is that you're placing these liens and when those homes are going to sell. Because this is all
right,
cash flow, it's all timing.
right. Yeah, and I assume it's not that simple to foreclose on something. A lot of notices and, a lot of process there.
Well, yeah, not only that, but you need to look at like the market in the area of which you are living and working. How are how are these homes selling? Are they selling quickly, slow? Are they going over asking, under asking? There's a lot of market effects that you need to take into consideration too if you're going to go down that road.
Yeah, exactly. And just one more follow-up on that, and we can move on to our next disaster, but um, suing clients for unpaid fees. I don't think my firm ever did that once in 35 years. And, you know, is have you been able to do that successfully without a bunch of counterclaims? And, just what are your thoughts about uh, collecting in that way?
Yeah, it's something that we try and avoid at all cost. I mean, if you're really good about your collections and your collection process, you don't really wind up getting to this point because you're working out ahead and in front of the client, which is much as what we've talked about up to this point.
Right.
Um, but should you have to go down that route? Yes, there are very specific procedural processes that you need to follow. Number one, depending on how your retainer is structured and how it is that you've agreed to, handle these types of issues with them. Uh, Best case scenario is that you're owed a certain sum of money and you can set up a payment plan or some sort of payment arrangement, and you don't have to go through arbitration or sue the client. That's
Right.
best case
Hmm.
scenario.
Hmm.
Um, but should you have to go down that road, it is a good leverage point to try and get, you know, some money that you otherwise wouldn't have seen by going this route. But it's not something that I highly recommend. It is pretty arduous, and it requires a lot of, attention to detail, and it's very time consuming.
Yeah.
Um,
Yeah.
yeah, I can't say it's overwhelmingly successful, and it's something that we try and avoid at all costs. But depending on how big that number is that you're owed, it might be worth going down that road.
Hmm. One last thing there, which is, um, you know, what we were always afraid of is that you have a malpractice claim that comes with the collections. Is that been your experience as well?
Yes, statutorily, I think you need to wait a certain threshold here in California. I think it's a year before they can file any malpractice claim. If you have
Ah,
gone past that year, then you're kind of beyond the statute there to
got it.
um,
Got
not
it.
have to deal with that issue. So
Okay. Well, you can certainly see the potential for disaster in this one. And Matthew's given us some good advice about how to avoid it and how to deal with it. So we have a bunch of more notes on this topic in the slides. I'm just going to go through those really quickly. So when you get the recording, if you want to take a look at any of those details, there's that's all in here. But all right, let's move on to disaster number 2. Okay, so I'm the managing partner and I receive a resignation notice from my top producing partner, somebody who brings in 30% of the firm's revenue. So in the next few months, some of the clients start to follow that partner to a competing firm, and now we're struggling to maintain financial stability. What should I do, and what could I have done to prevent that?
Yeah, so I, we we've all been part of situations that have transpired just like this. Um, sometimes it's cheaper to try and keep them there, just like in family law, we like to say it's cheaper to keep them. Um, this could apply here too. If a partner lets you know that they are resigning and they're going somewhere else, either to another firm or opening up their own practice, it's been my experience that sometimes you can meet them in the middle somewhere and that they don't have to leave. So I would, step one, ask, um, to prevent something like this. Hey, what is it that we can do to keep you to stay? Because especially with this particular partner who's bringing in 30% of the firm's revenue, that's an important piece to your business and to your practice. And if there's some concessions that you can make to keep them around, assuming they're still profitable, it might make a lot of sense to try and make those concessions. But if you are beyond that point and there is no room to try and keep them there, then yeah, there's a few steps that you can do before that person then leaves. We've had this sometimes where they've decided to go, and you got to put together something like an election letter, and there are a whole bunch of administrative procedural things that you need to do in order to get this person ready to exit or expedite this process because they already left. So now we have to deal with not only the loss of this revenue generator, but now we have to think about clients, and if clients are staying or going in this particular situation, we have several clients that are going to follow this person, and that's more lost revenue. A good way to figure out how big of a loss this might be is, seeing, number one, that revenue piece, and how is our firm going to be able to sustain without this person being here? So if you are running any profitability numbers or just gross revenue numbers and figuring out and doing the math in your head or on a spreadsheet, okay, this is going to be our loss just with this person leaving. And then figuring out also what those losses might be with any particular clients that also might be going with them. It might be wise to hop on the phone if you are, the partner or one of the other partners, to maybe see where these clients are indicating on where they're going. And if they, like to stay, obviously you have that election letter that still has to go out,
Right.
so that the client can elect where it is that they want to go. But those are the ways that I might handle something like that, where number one, try and get them to stay if you can. Number two, if you can't do that, I'd I'd get in front of that person and get those processes in place where, hey, you're leaving, we have to deal with this on the client front, and then having those conversations with the client as well.
Right. Have you had to do that?
Oh yes.
Okay.
Oh yes.
All right. Just give us a little, a little gloss on what those conversations with the clients are like.
We've had a managing partner or partners where they have to, get on the phone with the client, but hopefully they've worked with them in the past in some capacity,
Right.
where you're coming to them in that way, like, hey, we have this partner leaving, uh we're going to have this person or these people replace this person no longer being here. You will still be you'll be serviced and satisfied with still staying with our firm. If there's not an existing relationship there with the firm and that client, and it was just more so this particular partner, you probably don't have that conversation with them. And,
Right.
just kind of like let the process play out a little bit. I mean, we don't want to interfere with any, future business for this departing partner. We don't want to,
Right.
have a lawsuit wind up here where, you're interfering with my future practice. So if there's an existing relationship, it seems like that might be appropriate, but you could also let the election letter process just kind of do its thing as well.
Right. Right. So this is, obviously, I mean, it's kind of like you're in a no-win situation at the point that this partner leaves. I mean, this is something bad, really bad has happened. So the, I think the preventive part of this is the most important one, the most important part. So talk a little bit about, how you keep your partners happy so that they're not going to leave.
Well, I think it's exactly what you touched on. It's clear communication often, making sure that, their needs are being met, that they're being heard, they're given a space to voice their opinions, and they can feel like they're contributors to um, what's happening at the firm and where the firm is going.
Mhm.
Another good point that you already made is compensation. Like, how is that being dealt with? How is that being handled? So number one, is it objective? Is it clear? Is it easy to follow? That's a big reason why a lot of people aren't, or why a lot of people go, is because the compensation factor of it. If you can sit
Mhm.
down and kind of figure that out and make them a part of it, um, I feel like that would be a good way to make sure that that they're going to stick around. I mean, all people part of your firm are very important. I mean, that's law firm life. Those are your most important assets, are your people. We're all very labor intensive, and that's where most of our costs go, to the people that it is that we employ at law firms.
Right.
So being transparent, being open, and giving people space to contribute, I feel is, the best way to keep not only partners but just anybody around.
Talk about culture a little bit, and I've kind of laid my ideas out there a little, but tell me how that plays in with the firms that you work with.
Yeah, culture, I feel, is arguably the biggest and most important part of a business, because that is what your firm eats and breathes. Like that, it is like the living organism that is your business, is the culture of that firm. And if it's a toxic one, you're going to see a lot of turnover, which is costly, as we all know. You're going to see unhappy employees, which are going to make unhappy clients,
Hmm.
and it has a very big trickle down effect to not only the reputation of your business, but of yourself as well. So making sure that your culture is a good place for people to go work, and that they're happy where they are working, and that they are working with people that they enjoy working with, not only, other employees or partners, but also the clients that you bring in.
Hmm.
It's important that you're looking out for your employees on that part too, where you're bringing in clients that, are respectful to your staff. And, if your staff and your employees can feel that, it's just going to make for a better culture and better environment, where people are going to be productive. They're going to make you more money, and you're going to enjoy going into work every day.
Yeah, yeah. So, as I think back on my experience in law firms, the first three law firms I worked for, their culture was not, I mean, mostly accidental. It's like people showed up for work and they did work, but there was no cultivation of what it meant to work there, what the firm valued, anything like that. And then I walked into my final law firm, and they had like these 3 pages of bullets about, here's what the firm's about. And, so everybody knew that it, that, uh, exactly what was expected as far as that goes. And, it was about primarily paying people for the work that they did, and not, there's, very relatively little placed on longevity in the firm, much more on production, valuing people's diversity. And that firm happened to be politically diverse more than any other way. But, but all that was laid out in a this statement of values, essentially. And that helped so much. It's like it just brought that clarity to it all that made all the difference. So, I mean, you can't manufacture a culture, right?
No.
But you can you can mold it and create it, and at least be explicit about what it is. And I really value that from my experience.
Yeah, you need to be intentional with it, and it needs to be
Yeah,
shared, and that
yeah,
expectation needs to be shared, and it needs to be made clear, um, just to get everybody on the same page, row the boat in the same direction, and that's really very important.
exactly, exactly. Any more thoughts on the exiting partner?
Yeah, I think a really big part of this is having that secondary plan or that contingency plan as this person is leaving.
Mm,
You need to figure out what your next steps are. This person's out the door, they're gone. What is it that we can do with the existing business that we do have? Who can we plug in to maybe somehow make up for some of this lost revenue or a lost clientele? Do we put in a different marketing plan? Do
hmm
we try and tack a different, subset of clientele? How is it that we are going to, are we going to have to change our business model and structure with the loss of this person? Are we going to have to ask people to bill more hours? Are we going to try and increase our collection rates? Are we going to have to change how it is that we're invoicing or what types of clients we're working on? I mean, that's where once this person does depart, you need to find ways to make up this loss generated revenue, because likely with the departure of this person, your costs aren't going to decrease substantially, and you were largely making money on this person, or probably making money off of this partner. They were a profit center. Your profit center has now left, which means additional profit to you is now also out the door. But your cost from losing this person is not going to offset that. So you need to then think about, all right, how am I going to make that up? And there are a lot of different ways that you can do that, depending on what type of practice you have. If you're in an hourly practice, you got to think about your triggers that you pull there on either rates, um, standard or average rates, your collection rates, um, and or hours that you're going to bill. If it's flat fee, you got to try and go get more cases or be more
hmm
efficient with those cases, become more profitable. And then if it's contingency, you have to be a little more strategic on how your money is coming in the door, because that is very based on timing with the courts and when it is you're going to receive those funds. So you got to start planning for the future and start planning right away.
Yeah, exactly. That's a really great point. Yeah, the world, it might seem like the world ended, but it's but it's going to go on, and
Yeah,
it's
it's going to keep
not going to be
rotating.
good for you if you don't plan for it. Great point. Shall we move to our third disaster?
Sure.
And I've again got a bunch of notes in the slides for you all to peruse later. Go through those, and all right, now we go to disaster number 3. And I forgot to mention this earlier, but if anybody has any questions, feel free to jump in now, or we will have a little bit of time at the end. Just raise your hand or say something in the chat here. Let's see what we got. Something in the chat. Before we jump into this last one, there was a question. So it's any tips on ensuring received fees are protected from a bankruptcy clawback?
Oh, I do not have any experience in that. I'm sorry, I could not speak intelligently on that.
Yeah, I know enough to be dangerous on that, unfortunately. But I believe there's a timing associated with that any fees received within a certain period of time before the bankruptcy declaration are subject to the clawback. And beyond that, I'm afraid I don't have any any great tips. Get paid earlier. That's a all right, so let's jump back into disaster number 3. So, you've had the excitement of having your partner leave. You've had the terror of the unpaid invoices and that, but now you have that feeling in the terrible feeling in your pit of the gut of your gut because there's no clients coming in. And this, every lawyer I know just dreads this. It's they're used to being busy, and suddenly it's not busy. And you start, the clock is ticking. You're paying staff, and you're not getting the business that you need. So what do you do in that circumstances? And then, if you knew it was coming, how would you have planned for it?
Yeah, I know firms tackle this a lot of different ways. And some of the ways that we've tackled this, um, we're really big on being out in front of our inventory. So that means, we are closely tracking cases and specifically how often those cases are being touched. We like to be very transparent with our attorneys, and they love this report. We have a case touch report, and it's simply just letting them know what cases they have touched over a specific period of time. So we have a biweekly billing cycle, and we update them on a biweekly basis on their accounts receivable or their inventory, their client list, letting them know the percentage of cases that they touched over that time period. And
And that's just based on whether they bill to the file.
Correct.
Yeah.
Yes.
Okay.
So
Makes
we
sense.
will run a historical report. It's obviously it's not like an active report that we are running, all the time, but it's historical data. And it just lets the attorney know, hey, here's your case list, here's where they sit financially, here's how much work you've put on this client as a percentage of the amount of time that you put on this client with the total amount of time that you put on. And here it was the last time you touched that case. And it is a really good way to communicate with the attorneys nicely. Hey, this is what you've touched. Hey, this is also what you haven't touched. And many times it's eye-opening for them to like, wow, I haven't touched that case in that long. I should probably go dust off the file and give that client a call or go take a look
Yeah,
at it.
exactly.
And that's a really nice way of communicating with the attorneys on that front, just letting them know where it is that they stand on their inventory. So that's probably step one. Um, Number two, I mean, I'm not a fan of this. This is not any way that I would run a practice, but you could go down the checklist approach. I know plenty of firms that, they're a very checklist oriented firm where they have their clients all run through like the same processes. And it's a
Mm-hmm.
way to um, streamline the work and have the work done in a specific way. I think it takes away from the attorney's creativity and how it is that they want to work a case. But some firms are very strict and they want them to work cases up a very certain way. And if you're taking that checklist approach, it lets them know where it is that where their next steps are and work to be done. Because oftentimes, as humans, we're all deadline driven. And unless there's a deadline, we're not
Right.
going to do it, or we're going to wait till the deadline. which then might make this feeling of, the well is drying up here. The faucet's turned off. I don't have any work to do. There's not a deadline for another, X number of days or weeks or months. So that's another approach that you could take is, lay out how it is you want cases to be worked up. They know what their next steps are, and they may be able to find voids there as well.
Very
And
good.
then
Yes. Mhm.
and then the third way that I might tackle this is um, my favorite, which is like the Kanban board approach, where you're really trying to figure out where your bottlenecks are. And for those of you that don't know a Kanban board, this was really, really big in manufacturing, where they had, much like the checklist approach, you have big boards and the process is set up um, on like cards that you can just move down the line. Um, you can use some software like Trello with that. I know Rocket Matter, who we've used, they have a Kanban board. I don't know how well it works, but I know that they have one.
Mhm.
Um, but Trello is a really good way to use this as well. And you're just moving that card, that case through the process. And you can see where any of those bottlenecks are in your process, where you could see cases just stacked up in one certain area. Not only would your staff know what is to be done next, but you can know where things are stopping, where the work is stopping. So that's another good way to go as well.
Yeah. So just sort of at a high level, what you're suggesting is, a lot of firms, you've got work to do on the cases that you already have, right? So let's say you've exhausted that. We're, now we're kind of doing everything we can on the cases we've got. Um, I've always heard that you get 85% of your work from and experienced from the clients you already have. So, what's the strategy for going out and seeing if you can scrounge up some new work from your new existing clients?
It's time to start. It's time to start marketing yourself, marketing the firm. Hopefully you're doing this well before you get to this point when your associates come to you or you've run out of work. You got to be a little forward thinking here,
Right. Hmm.
and you got to start getting out there because the sales cycle on most marketing efforts is pretty long, unless you're going to go down, you know, the pay per click, very saturated and very expensive marketing cycle that way. That's what will get you a lot of calls quickly, but most marketing takes a long time.
Right.
So I'd be going to marketing events. I'd be reaching out to my attorney friends. I'd be busy on LinkedIn. And it's sometimes you got to hustle to go find work, but diversifying whatever your marketing plan is and being consistent with that over a long period of time is going to help ensure that you're going to have cases coming in that pipeline and keeping you busy.
Nice. Nice. We just got a couple more minutes, and we did have a few questions and comments come in. First from Tiffany. It says, if projections look grim, when do you decide to do a layoff?
Ooh, when projections look grim, when do you decide to do a layoff? Well, there's a lot of other costs that I would try and cut before I were to do any layoffs. I mean, that is probably the last thing that I would want to do before you get to that point. But runway is going to be really important to you and whatever your firm feels comfortable with as far as those projections and that runway. For us, we like to project, at least a year in advance. How much runway do we have? How much cash do we have in reserves? How long will this last us should we continue to go down this road? If those projections do seem grim, hopefully you can make a lot of those changes well before you're going to have to lay anybody off. If you're not projecting or not understanding your cash flow and your runway very well, um, I can't say that there's any, you know, bright line mark or rule that you should be following. Like you need to hit layoffs if you only have 3 months of runway left. That's
Yeah.
going to be very subjective on a firm by firm basis, but People like to have, at least 3 months in reserves, 6 months in reserves, a year in reserves to sustain these slow times.
Mhm.
So it's going to be very subjective, but it's very important that you understand your cash flow and know your runway and have the conversation about what we feel comfortable to have for a runway before we have to make any of those
Yeah.
decisions.
I just wanted to add a couple of comments there. One is, if you're going to lay off an attorney or a paralegal, you're laying off your production capacity. So that's, you're potentially shooting yourself in the foot if you do that. The other thing is that a very good strategy is to make sure it is that your partners are delegating as much as they can, even if that might be making them a little bit light, because the partners are the ones who have the potential to go out and get more work.
Yeah.
And they tend to hoard when things get slow, and that can be really counterproductive because they're still busy. The associates they're working with are not, and but if they delegated, then they're in much better position to go out and get new work. And just I want to acknowledge Andrew's comments here. One of them is don't let AR go over 90 days. That's certainly something to live by. And then I think he's saying essentially what we did is it's difficult to collect pre-existing debt when a client files bankruptcy. That makes total sense to me. All right, so do you have anything you want to add there?
No, no,
No,
no, no.
okay, very good. All right, well, we're out of time, folks. I really appreciate your joining us today. I hope you got something valuable out of this webinar. If your firm is in need of business consulting and the kinds of things that Matthew does, remember it's Unravel Legal is the name of his firm, and we hope to see you again on one of our best-in-class law firm webinars. Thanks, everybody, and we are adjourned.
Thank you,
Thank.
Gary. Thank you, everyone.
All right. Thanks, Matthew. Appreciate your time today.
Thank you.
Bye now.